Based on the case Mr. Maximus versus Bank Berjaya, we have identified the main issue, which is whether Mr. Maximus can hold Bank Berjaya liable for the amount paid out on the forged check, considering Ms. Naughty forgery and Mr. Maximus' failure to examine his bank statement. The first legal implication is bank liability for honoring forgery check. Bank Berjaya honored the forged check presented by Ms. Naughty, resulting in Mr. Max's account being debited. The liability of the bank in such case is determined by the legal principle of agency or negligence. Under the common law, the bank duty is to exercise reasonable care and skill in processing transactions and ensuring the authenticity of the signatories. This duty arises from the banker-customer relationship and cash flow. If the bank fails to fulfill this duty, it may be held liable for the loss suffered by the customer. In Malaysia, the legal principle governing a bank's liability of forged check are primarily established through case law, which is the court held that a bank is generally liable for the payment of a forged check if it fails to exercise reasonable care and skill. Second, customer duty to examine bank statement. Bank Berjaya argues that Mr. Max has a duty to examine his periodical bank statement to ensure the accuracy of his account and report any discrepancy to the bank. Under the common law duty of a customer, which is duty of taking reasonable care in drawing check and duty to disclose forgery once he aware of it. In this case, Bank Berjaya contends that Mr. Max's failure to examine his bank statement, while there is no specific statutory provision in Malaysia that mandates customers to examine their bank statement, the court have recognized the principle of contributory negligence in certain cases. If it is established that Mr. Max's failure to examine his bank statement contribute to the loss, the court may reduce the damage award to him accordingly. The third implication is forgery by Mrs. Naughty drawn on Bank Berjaya between July and December 2022. Forgery is a criminal offense and generally dealt under criminal law provisions. In this case, Mrs. Naughty committed a fraudulent act by forging the check without being an authorized signatory. Under Malaysian law, forgery is addressed in Section 463 of the Penal Code. If Mrs. Naughty found guilty of forgery, she may face imprisonment for a term that may extend up to 10 years, a fine, or both. Section 24 of the Bill Exchange Act 1949, the bank has no right to make payment on a check with a forged signature or without authorization, even if the forger is innocent, which caused the bank to be liable for conversion or strict liability tort. Next, under the protection of a bank, the implication of Section 82(1) and 2, this provision provide protection to bankers who make payments on checks that lack proper endorsement or have irregular endorsement. If the payment is made in a good faith and in the ordinary course of business, the bank will not be held liable for any deficiency or irregularity in the endorsement. Under the protection of a bank, the implication of Section 82(1) and 2, this provision provide protection to bankers who make payments on checks that lack proper endorsement or have irregular endorsement. If the payment is made in a good faith and in the ordinary course of business, the bank will not be held liable for any deficiency or irregularity in the endorsement. Last, protection under Bill of Exchange Act 1949, Bank Berjaya asserts that they should be protected under the Bills of Exchange Act 1949. The Act provides protection to banks that have paid checks in a good faith and in the ordinary course of business, that a banker who has in a good faith without negligence received payment for a customer of a check crossed generally or especially to himself shall not, in case the title to the check prove defective, incur any liability to the true owner of the check by reason only of having received such payment. In this case, if a Bank Berjaya can prove that they act in a good faith without negligence in honoring the forged check, they may be able to rely on the protection provided by the Bill of Exchange.
Next, whether Bank Berjaya can be held liable for forgery check. Customer has a duty to disclose forgery and take reasonable care of his account, where there is no specific statutory provision mandating customer to examine their bank statement in leisure. But the court has recognized the duty of customer to exercise reasonable care in monitoring their account. If Mr. Maximus failed to examine his periodical bank statement and report any discrepancy to the bank, he may consider contribution negligence and effect the claim based on his failure to fulfill these duties. According to United Eisen Berhad vs. Thai Songhae Construction Sudan Berhad, the court determined that his banker had honored the fact of check written off his account and that he merely needed to prove a forgery on a bank balance profitability. The exempted rule is strictly liable for making payment on forgery instrument if the customer claimed, based on the thought of conventions. Therefore, the banks who paid the forgery instrument is liable to pay the loss. This is because there are only two duties on the client at common law and no duty on the client to prevent forgery on the part of slave. For issue number 2, in section 24, the bank has no right to make payment on forgery check or unauthorized signature. The pay of bank on forgery instrument may escape liability in the negligence of Mr. Maximus in drawing the check facilitated of forgery instrument. In the case of Thai Hing Cotton Mills vs. Liu Chong-hing, the Privy Council held that there is no other duty to take reasonable precaution other than the duty to make check with care. In this case, which party contributed to the forgery of the instruments will be liable. For issue number 3, the bank could probably argue Mr. Maximus has a duty to take precaution to prevent forgery by his employer, but they should have checked his bank statement first to identify any discrepancy. Therefore, the bank can assert that it was acted in good faith by honoring the forgery check, where the bank can defend its legal right under Section 82. In the case of Thai Songhai, 97 fact check amounting about 1.5 million were cleared over a period of 3 years. The bank tried to claim that the customer has a duty to ensure that his check was not forged by his employers. In another case of Marfani & Co. vs. Midland Bank, stated that he delivered the check for payment to the bank where the check was drawn, accepted payment and credited to the account of his customer. Either when the check is received from the customer, he presents to his banker for collecting and remind the nonsense to produce in accountable to the junior of owner in the check for amount he's received in common law under Section 73A. As a result, if it's discovered that Bank Berjaya failed to take reasonable precaution in verifying the signature, the bank may be legally obligated to reimburse Mr. Maximus for the sum paid on the forgery check. However, Bank Berjaya defends of Mr. Maximus' duty in effect bank statement as well as the protection afforded by the Bill of Action Act 1959. Finally, the conclusion of Bank Berjaya liability will be based on analysis of all relevant facts and the legal arguments that have been discovered to determine whether or not Bank Berjaya is truly guilty.
For the second question, the issue is whether Madam Sasa is liable for Mr. Sim's overdraft facility because she contends that when she signed the guarantee paperwork, she thought that she was serving only as a witness but not as a guarantor. In contract law, a guarantee is a person who agrees to fulfill the obligation of another person in the event of default. Guarantee agreement is a contract where the guarantor makes promise to the creditor to fulfill the debtor's obligation if the debtor's default. The guarantee must be in writing and signed by the guarantor as per Section 25(1)(b) of the Contract Act. The terms of the guarantee agreement will be determine the liability of the guarantor. Based on the provided information, the suitable act that may be relevant to the situation is contract law. Contract law governs the formation, preparation, and enforcement of agreement between parties. In this case, the key issue is whether Madam Sasa can be held responsible as a guarantor for the overdraft facility obtained by Mr. Sim. The determination of responsibility will depend on the terms and conditions of the guarantee document she signed, as well as the circumstances surrounding by the signing of the documents. To establish Madam Sassa's liability, Bank Berjaya will need to demonstrate that she willingly and knowingly agreed to act as a guarantor for Mr. Singh's overdraft facility. If Madam Sassa can provide evidence or argue that she signed the documents under false pretense or that she genuinely believed she was signing as a witness and not as guarantor, it may affect her liability. The interpretation of the guarantee documents, along with any supporting evidence and applicable contract laws, will be crucial in determining the outcome of the situation. It is advisable for Madam Sassa to consult with a legal professional who can review the specific details of the case and provide the guidance based on the relevant contract law in her jurisdiction.
Okay, next part is application. In the case of Red Bank versus Bundy, the plaintiff bank ventured to loan the defendant Mr. Bundy and his mother served as a surety. The bank representative, however, gave Mr. Bundy's mother a different explanation when presenting the guarantee paperwork, caused her to assume that she was only recognizing the transaction as a witness. The bank attempted to enforce the guarantee against the mother after Mr. Bundy missed payment on the loan. The bank office false statement qualified as a fraudulent mispresentation and the court found in favor of the defendant. The court emphasized that a person cannot be held liable for the violation of a document if their sign is while misled by a deceptive representation. The circumstance in Red Bank versus Bundy is analogous to Madam Sassa's claim that she signed the guarantee paperwork as a witness rather than a guarantor. Madam Sassa, who is illiterate, relied on Mr. Sim's misrepresentation of the significance of her signature. As a result, she could possess a strong defense against being held accountable for the facility as a guarantor. According to Red Bank versus Bundy, the outcome of Madam Sassa's case will rely on the detailed and supporting evidence. The discussion does, however, establish the general rules that a person cannot be held responsible for a document provision if they sign it when misled by dishonest representation. For Madam Sassa's situation, she signed the guarantee form under the mistaken impression that she was just serving as a witness, not a guarantor in her case. So, she may have a power defense against being held liable for the facility if she can present proof to back up her allegation, such as witness testimony or any other paperwork. To resolve the conflict, Madam Sassa will have to argue her position and provide supporting document in court or in decision with Bank Berjaya. She should look for legal counsel to make sure her rights and interests are safeguarded. Okay, the last is conclusion. The conclusion for Miss Sassa's case is that she could have a strong defense against being held responsible for the facility as a guarantor based on the case of Red Bank versus Bundy. This decision established that a person cannot be held responsible for a document provision if their sign is while missed by deceptive representation. Additionally, Ms. Sassa cannot read or write, so she relies on Mr. Sim's false claim that he signed the contract as a witness rather than a guarantor. Madam Sassa may contend that she should not be held accountable for the facility if he provides proof that Miss Sim fraudulently persuaded him to sign the warranty instrument under false pretenses. Finally, Miss Sasa needs to obtain legal advice, and representation is highly advised for Miss Sasa. So, a person should be professional in the law who can assess the specified circumstance, review the warranty document, and analyze the applicable contract law in relevant jurisdiction. This will cause them to be able to provide informed guidance and present the best argument for Miss Sasa's case. So, Miss Sasa will be free from the accused in the case against her. Thank you.